This is the panel on, what is the official name of our panel?
Law enforcement access. We're going to go.
Law enforcement access to information.
Lawful.
And we have different perspectives on this panel. I'm going to take the perspective of the person that's been requested information of, or as I like to think of it as how not to ask a question of a librarian. I'm the founder and digital librarian of the Internet Archive, which is a nonprofit library in San Francisco, and we had the delight of getting one of those nasty national security letters that have a gag behind it.
What is your name?
Oh, my name is Brewster Kale. And so we're going to keep this short enough so we can actually have some level of discussion and back and forth. So we run I run an organization that has a lot of material from end users up on the internet. We're probably best known for the Wayback Machine, but we also host books, music, and video at massive scale. We have petabytes of information to make it available, but as a library. So there was a day when we were visited by a couple of FBI agents. They came knocking at the door, and they met with our office manager. We don't have legal staff, so the office manager said, you kind of came to the wrong place. If you want to talk to our lawyers, you have to go and meet with our lawyers, which are the Electronic Frontier Foundation. So they went to the Electronic Frontier Foundation and then met with them, and then I got a call. And he said, well, we can't really tell you over the telephone what it is we're going to talk about, but we need a meeting. And so we met in a conference room at the Internet Archive. They specifically asked him not the people that were, the FBI agents, you can't talk about this on telephones, which I guess we're now starting to understand why. So we met in a conference room, and he said, this is not a good day for you, Brewster. We've just received a national security letter. It's one of these national security letters that has a gag order to it, so that not only do you have to just answer the questions, and you can only ask people what it is they've been allowed to, that you need to be able to answer these questions, you can never talk with anybody ever again that these questions ever came in. This is not how you ask a question of a librarian. We're in the business of answering questions for people, and this is not one of them. It was very uncomfortable. I didn't know what it is I could do, so I asked, what can I do? And they said, well, you can basically, according to the law, answer it quickly, and then never talk about it again. And I said, or what? And I said, well, you could risk criminal charges and go away for 5 years. Said, is there any other options? And they said, well, not really, but so the only way that you can push back on one of these things is to sue the United States government. So that's a little drastic. Is there somebody I can consult? I said, no. Can I ask my board? No. Can I bring this up with my family? No. You have to make a decision on your own to sue the United States government about this, and even if you sue the United States government, it will probably take so long that you'll miss the deadlines, so that you'll risk criminal charges just by doing this. So, oh, this is thrilling. Yeah, you're right, this isn't the best day of my life. Well, so I had to think about it, and on my own, we decided to sue the United States government. The ACLU and the Electronic Frontier Foundation offered pro bono help, which turned out to be absolutely critical, because if I'd started to spend money on lawyers' fees, then other parts of the organization would start to know that something was up. So it's very, very peculiar, very Kafkaesque. It's sort of just, you can't respond in these environments unless you have a friend such as the Electronic Frontier Foundation. So we filed a suit that was under seal. It wasn't with the secret courts, but it was under seal, so that there was complete secrecy about it. And it started a very nerve-wracking several months. What happened after we sued, it turned out that the FBI didn't need the information after all. And they basically wanted out. They just said, we're done, it's okay, just go away. We're over. Doesn't matter. And we said, not so fast. That if we've gotten this far, we want to make a cookbook for those that are in my situation, such that we want to go public with as much information about the demands and all of the counter back and forth that are going to go on as part of this, and we want to be able to post it on the internet for free public access. And so we did this negotiation with the FBI, and of sort of when would be redacted and by when, so that they couldn't drag it out forever and ever. And this is a negotiation that took several months, and then it was cleared up. All in all, about 6 months later, and we had a press call to be able to announce that this is one of the only of the three, at least at the time, public pushbacks against these national security letters. There have been hundreds of thousands of these, we know, because Congress demanded to know how many there were, and that was a lowball estimate, because a lot of these national security letters are never even written down. They're just call up, hey, I've got a national security letter, you got to give me the answers, as according to this congressional report. So there was only three that have pushed back, and so we did, and we finally went public with it. What was, I think, very helpful out of this is some of what it is we wanted to know was how would our partners react to this. The Internet Archive works closely with the Library of Congress, with the National Archives, with governments around the world to work with them on collecting web pages and being a library and digitizing books and the like. And when you sue the United States government, there's this question of sort of what would happen, and given that the United States government isn't all of one mind, when the announcement came out in the Washington Post, there was a conference call back and forth, normal conference call back and forth with the Internet Archive and the Library of Congress, and the people that we were working with said, I heard this clatter on the other side, and they said, Brewster, you can't actually see what it is we're doing here, but we're all standing and giving a round of applause to the Internet Archive. So the idea of pushing back on these can not only, you can do it, but it often is, you have more friends than you can imagine. So this is the creepy thing about all of this had to be done in secret. That there was no one I could talk to, I couldn't clear it with my board, there was nothing I could really feel that I could do. So this area that we've started to find is as a the government in this circumstance, by keeping things secret, are causing a level of distrust. That they're not trusting us, and they are not, in many ways, being trustworthy. And going into this period, as the government becomes less trusting and less trustworthy, I think is a very dangerous period, and something that our community can do to do something about it. I'll give another example. After all of this simmered down, I went for a Freedom of Information Act request. This is after this whole thing was done. Senator Feinstein had sent a letter to the FBI demanding, how the heck did you go after the Internet Archive for this? That the head of the FBI said that this is an absolutely critical thing. We need all of this information to fight the terrorists, which obviously wasn't true. But it was stated, calling us out in a speech. I asked for a Freedom of Information Act request around Brewster Kahle and the Internet Archive. And they sent back a letter, said, we've searched, never heard of you. What? How can this possibly be true? So I wrote them another letter and said, it can't be true. We sued you. There's all this back and forth. There's letters. How can you never heard of us? They sent back another nice letter. Said we searched in this 5-letter acronym database, and nope, never heard of you. Thanks. Have a very nice day. So it's shaking my confidence daily, I guess, is the of what's going on, and it makes me so that I'm not really sure if I can trust what it is that's being said. With that, thank you. The next speaker.
Okay. Hi, my name is Jen Valentino. I'm a reporter at the Wall Street Journal. I've been covering digital privacy, surveillance, and legal issues for a while now, and my job on this panel is to give you a perspective on the ways in which secret surveillance can affect our society. In some cases, the people who might be your customers, like me, other journalists, and just members of the public. One disclaimer at the beginning, I'm not here to say that we shouldn't have surveillance. I think actually that this has been well established by Congress and the courts that you need warrants to surveil suspects. You need surveillance for foreign intelligence purposes. But I think that my job as a reporter is to make sure that the public is informed so we can have a discussion about what's going on. And I think when it comes in particular to surveillance, because it's oftentimes really complicated, people just don't know actually what is going on. So the public at large might know much less about this than you do working in a technology field. For example, with the recent disclosures about the NSA, it took weeks before people even really understood, I think, what metadata is, just the existence of it, that it's a thing. And kind of to give you an example of this, I mean, how many people here before the Snowden revelations came out would have guessed that, probably the NSA had collected some sort of their data at some point? And I think, yeah, right.
Skewed sample. Yeah. It's a skewed sample.
They're opening a file on all of you now.
Right. I don't think it's surprising to people who deal with computer security that was happening, but this was after those disclosures came out. The Pew Research Center did a survey. This was in June, so this had all been discussed, and even then, only 54% of Americans in the survey thought that the government probably had collected any data about their phone calls. So that number should obviously be, much closer to 100, because we know that they've been conducting bulk collection of people's phone metadata, and 63% felt that this would violate their privacy. So I think one thing to think about if you are in a position of receiving requests for law enforcement access or backdoors into equipment, if this is something that you're dealing with, I think it's important to consider that customers, the regular public, might not understand exactly what is possible. So when I report on surveillance or data gathering, whether it's by governments or corporations, I get basically two reactions to the same story. And one is, this is kind of, I think oftentimes you guys represent, the idea that it's just not news. Everybody knows that the NSA can get this. Everybody knows that Google and other companies in Silicon Valley are going through, they're looking at your emails to serve you ads, duh. But honestly, a lot of the general audience, our readers, respond by freaking out. And they really are not aware of this. So I think people who are dealing with these requests are in a really a position of a lot of responsibility, and they probably know more about these systems than they give themselves credit for. And in some cases, I think people who don't know these systems are relying on them to protect them. So another thing that people don't really know about is something that's called the third-party doctrine. This has come up a lot recently in these NSA discussions, and it's part of the reasoning behind why it's okay to gather this metadata. Basically, the third-party doctrine says that that if you give up your information, such as telephone metadata, that you've given it to another company, you don't have an expectation of privacy, so the government doesn't need a warrant to get it. And this has been the case since 1979, and there were some earlier cases that were related to that as well. But it's now that we have so much data out there that's mediated by third parties, this is actually being challenged. As of last year, this wasn't a majority opinion, but within the Supreme Court, Justice Sotomayor actually raised this issue and pointed out that this concept that has been standard legal doctrine for decades is actually no longer suited to our digital age. So I think this is another thing to think about. My experience with this concept that's been around for more than 30 years at this point is that it's actually still news to most people that the government can get your information without a warrant if you've given it up to a third party. And it's worth considering whether the laws that are being used to access systems or gather people's information are really keeping up with technology. There are other privacy laws that companies like Google have been complaining about in Congress for several years now that allow access to emails that have been stored more than 180 days, because the law was written in the 80s when people couldn't fathom storing an email with a third party for that long, unless you just completely didn't care about it. And so it's not as though all of these concepts are entirely written in stone, and I think, in some cases they're worth questioning, but that's something you don't often hear about, as Brewster was mentioning, because of secrecy. So this is, I wrote a story about a different company that received a national security letter and was represented by the EFF. And so this is pretty typical of when this sort of information does come out at all, which is hardly ever, you get something that looks like this and is completely redacted. And I really like that they gave us the word additionally there at the bottom. That's like one of my favorite redactions ever. And it actually turned out to be helpful in figuring out what company this was, but I don't think they intended that to be helpful. I think it's just kind of mean. I don't know. Anyway, so I think secrecy is something that has a real effect on our democracy and society. As a journalist, this is something I believe strongly in. Funny thing is, the word secrecy is actually mentioned in the Constitution. So, obviously it's needed for some things. I keep confidential sources secret. People understand secretly their confidentiality agreements. Probably most of your employers have them. So I think it's something that is in fact important, but it can certainly be overused. And one of my favorite quotes about this is from a 1960 report from the House of Representatives that secrecy is the first refuge of incompetence, and it must, at a bare minimum, be at a bare minimum in a democratic society, for a fully informed public is the basis of self-government. And I think that is key in our discussions about surveillance that have come up recently. I wrote a story a couple weeks ago about how the FISA court, which is secret, redefined the term relevant to allow this bulk collection of phone records. The statute says that you can collect phone records as long as they're relevant to an investigation, and traditionally that has meant, if you're investigating a criminal enterprise, you have to look for things that pertain to that crime. But this court, in a secret ruling, determined that everybody's phone records could be relevant to this broad investigation into terrorism. And I think this interpretation was surprising to a lot of people, but of course it was secret. So another thing, if you receive a national security letter or something along those lines, I think it's worth asking yourself what exactly is meant by that. If somebody tells you that this is only going to be used for lawful intercept, what does that mean exactly? And I think with this level of secrecy around legal opinions, it's not, to be honest, entirely clear. And I think this raises some First Amendment questions. This level of secrecy. So companies from Silicon Valley are now challenging these gag orders that Brewster mentioned on First Amendment grounds, saying that they have a right to speak about this. And it's a tremendously interesting case for me as a journalist, because obviously the First Amendment is very important to us. And I think that this sort of scheme in which people are prevented from discussing anything or discussing the law really, raises some interesting questions. And if you are faced with a decision like that, and I think it's also, interesting to think about what you would do if people started questioning you and you couldn't talk about it or defend yourself. And I think for some companies, this is actually a business consideration as well. And so kind of to wrap up on the First Amendment line, we've also seen that as part of this increased surveillance and investigation of leaks, the government has been collecting information on journalists as well from the Associated Press. There's a reporter at Fox News who was labeled a co-conspirator so that his emails could be subject to a warrant. And just speaking personally, this affects my ability to do my job because people are not as willing to come forward and talk to me, even if they're not discussing classified material. I mean, they make nervous jokes about my emails being monitored or my phone calls being monitored. And when you're a journalist and you're in that sort of situation, it's disconcerting because whatever you think about journalists getting classified information, if people aren't willing to tell you about anything that's sensitive at all, about programs that are being mishandled or money that's being wasted, simply because they've been told not to talk about it and they're scared of being monitored, then we really face a problem in terms of informing the public. And so one last thing to mention, a lot of times I get the question, why should I care about this? If I'm not doing anything wrong, it shouldn't matter to me that the government has my information. And my response to that is usually that for some reason people always forget the Red Scare and they don't expect the Spanish Inquisition. But there are a lot of things in our past and that might be in our future that are problematic in terms of certain groups being labeled as doing something wrong when it's really not clear that they are. I'm not sure in all cases how you define what doing something wrong means and how you can say that definitely you're not doing anything wrong. We had a story last year about some college kids who signed up for a LGBT choir at college, and their choir director joined them to the group on Facebook, and it automatically sent out a note to their parents, even though they hadn't joined the Facebook group themselves. And this created a lot of problems for these kids, and I think that's a really good example of a situation in which some people would say they were doing something wrong and a lot of other people would not. But they were pretty much disowned by their families because of this privacy issue. And ultimately, I think that this is something that the people who wrote our Constitution were thinking about when they wrote the Fourth Amendment. I mean, that was a reaction to the British going through with general warrants and looking through everyone's homes. And, you know, if you didn't have anything to hide, maybe you actually would be okay with that. It's just a minor inconvenience, maybe. You want them to catch lawbreakers. And, you know, if you don't have any contraband, you shouldn't care that they're going through your house. But obviously, at least at some point in our history, some people thought that that wasn't the type of society we should live in. So thank you very much. And yeah, feel free to contact me if you have any documents you want to leak or anything like that. Thanks.
Okay. So I'm Matt Blaze. I'm a professor at the University of Pennsylvania, and I'm a computer scientist who studies, among other things, surveillance and surveillance technology. So I'm just going to talk about a couple of things. The purpose of this panel was to talk about, well, how should you react if you are given a secret surveillance order from the government to turn over information that that you've got in the course of your business or about your users or what have you. Something like the scary Kafkaesque experience that Brewster was describing, where you get a national security letter and you are told not only to turn over this information that you might not have collected in a form that the government is precisely asking for, but you can't actually get anyone's advice. You can't tell anyone about it. You can't resist it without some risk of being found in violation of a court order. The natural thing to do, I mean, certainly personally what I would do as a very much dyed-in-the-wool coward is comply. And I'm grateful that we have brave people like Brewster who will push back to say, hey, wait a minute, maybe this is unreasonable. But I think the vast majority of us will say, well, listen, it's in my interest to just comply with this and have it go away as soon as possible. And what I'd like to talk about very briefly is what we may lose if we do that from a technical point of view. We've talked a lot about what we lose from a civil liberties point of view, but there's another risk of secret surveillance infrastructure and secret surveillance interfaces that are put in very quietly in order to respond to an order that you immediately get that you weren't prepared for. And what are you going to naturally do as a technologist if you get such a thing? Well, you're going to put together some software and some hardware and some interconnections as absolutely quickly as possible to comply with it. And as we all know, writing software is a very easy process, and you always get it right the first time. And there's never anything wrong with what you initially do, and it never has any implications that you didn't anticipate when you first when you first implemented it. And in particular, software is particularly better if you can't ask anyone to test it for you. And this is effectively what we get asked to do when we have a secret surveillance order. Now, we don't know very much about how national security letters get complied with, what kinds of mechanisms are used to collect and deliver to the government the information requested in a national security letter, because it's secret. We can assume that these are put together relatively hurriedly, and we can assume that they are in general customized for each person who gets it. Each person who gets it, each company that gets it, has to figure out how to comply pretty much entirely on their own. But we don't know much about what those mechanisms are. We can't scrutinize them. We can't debug them. We can't ask if they have other implications or are creating other weaknesses because they're secret. One of the problems is that we've found that when the government in the law enforcement context, law enforcement wiretaps are certainly more prominent than national security wiretaps. But we know that one property of government wiretaps is that the people who are asking to have them wiretapped have a priority. What they are rewarded for, what they are judged by, is solving crime. Right? The purpose of a wiretap is to solve an existing crime. And what nobody we have found in wiretaps is asking is whether the implementation of this crime-solving technology creates the opportunity for new crime that wasn't there by weakening our infrastructure. And in fact, invariably what we've discovered is that creating interfaces to facilitate wiretapping makes systems weaker. It's a security vulnerability that's built in from the beginning. We've seen this in a number of ways. The most prominent, the most obvious is what's called the CALIA interfaces in telephone systems. CALIA is a standard wiretap system that all telephone switches are required to implement in the United States, and that allows the government to get access to call content and metadata when they have a legal authority to do so. One of the things that we've discovered is that every CALIA system that was evaluated by the National Security Agency when the government was buying phone switches for its own use were found to have security holes in them. And so in order to, enable wiretapping to solve one set of crimes, we're opening up these phone switches for new sets of crimes. Similarly, in Greece in 2004, there was something called the Athens Affair, in which over 100 government officials were found to be wiretapped, and we never found out who did it. We just found that the wiretap interfaces were turned on. A similar thing happened in Italy in 2006. Again, these wiretap interfaces just got turned on. We don't know who did it. We don't know what the motive was. What we do know is that in order to comply with this, we had this massive wiretapping that would not have happened if it weren't for this crime-solving technology. So one of the questions we have to ask is, how do we balance crime-solving with creating risks of new crimes from a technological point of view? Another example of this is what happens when you say, well, listen, I don't have any ability to comply with this wiretap order. You're asking me for something that I can't technically do. Well, in 2000, the FBI proposed a solution to this problem for example, internet providers who were unable to provide an internet connection, which was, oh, don't worry about it. Let us just come into your data center and we'll install this box on your network that will collect the data that we need. And oh, don't worry, this box has been very carefully vetted. And it won't affect your network or collect anything more than it was otherwise supposed to collect. So this is with wiretapping that's relatively open. In the criminal world, for criminal wiretaps, there's much less secrecy than there is in the national security cases. And here we've seen that the balance, even with this scrutiny, creates crime while it's attempting to solve it. On the national security side, we essentially have the same reward system. The national security authorities are there to prevent and solve terrorist activities, but they're not there to protect the infrastructure, and it's all under the cloak of secrecy. So from a technological point of view, whatever you think of the civil liberties side, this may not be actually buying us what we're trying to get. So let me turn it over to Alan.
Good afternoon. My name is Alan Davidson. I am a visiting scholar at MIT, but my claim to fame, I think, for being on this panel right now is that for probably about 7 years prior to that, starting in 2005, I was the director of public policy for Google in North and South America. I started Google's office in Washington and dealt with some of these issues as they came up for the company. And before that, actually, I was associate director at the Center for Democracy and Technology, where I actually lobbied against some of these provisions of the Patriot Act. And I'm here to really talk about not the technical piece, but the legal and business and public policy reasons for you to be asking questions, for all of us to be asking questions about the law enforcement and national security requests that we receive. So first, from a legal perspective, I should say when you get a request, your first stop should be to talk to your lawyer. Good job, Brewster. They train us to say this in law school, by the way. But the odds are that you will have to comply with the orders that you receive. But there is, as we've already discussed, some great ambiguity in the law. And what I don't think is widely understood, but is well understood, I think, among many of the lawyers who deal with these things, is that there is often a great deal of room for negotiation about the methods or terms of compliance for the orders that are given. And not always, but in a lot of cases. I think it's just worth recognizing, right? Law enforcement, national security agents, they have a job to do. They're seeking the most information they can get to prosecute somebody who they think is bad or stop something that they think is dangerous. But there's a lot of ambiguity in the way that these statutes are drafted. We talked briefly just about what does the word relevant, what does relevant to an investigation mean? And so what you often find, what we have often seen, is that it's common to get very broad orders that ultimately are not that responsive to the case at hand and maybe not even helpful to the FBI or whoever else you're getting the order from. It is very difficult to discuss specifics, but I can talk about one good story from my early days at Google that was public, and it was in 2006. And like all good internet stories, it involves pornography. At the time, the Justice Department was trying to defend a statute called COPA, the Children's Online Protection Act. It was ultimately found unconstitutional. It said that you couldn't commercially display certain harmful to minors material online ways that kids could see them. But in sort of last-ditch effort to try to defend this law, the Justice Department thought it would be a great idea to subpoena the search records from all of the major search providers, 2 months worth of search records for everybody in the United States, from Microsoft, AOL, Yahoo, Google, and others. And most of those other companies complied with the subpoena. But when we got the subpoena at Google, we were quite surprised because 2 months worth of search records is quite a number of records. It was literally billions and billions of records. And we could not, well, first of all, I couldn't understand why they would actually need it. And second of all, it seemed quite dangerous to be giving it out and setting a terrible precedent, a lot of private information in there. Because this happened to be a civil case, we were able to move to quash the subpoena. There was a lot of discussion. We were actually able to get in front of a judge, and ultimately the judge found, in fact, that this was not relevant. This did not meet the standards that were needed for this particular kind of subpoena, and ultimately reduced this request for billions of records down to ultimately Google had to produce 5,000 random search queries, and they were there was a process that the judge came through so that you didn't actually have to give out IP addresses or even what was in the queries. They were just categorized. But the point of this is, by asking and pushing back, we were able to narrow this from billions of records to 5,000 records. And that may be the high water mark. Your mileage may vary. Our mileage varied widely. But the point is that a lot of times, simply by asking questions, you can, and sometimes when you can, and Brewster's a great example, you can actually push back on these things. The second thing, a quick business perspective. We all know trust is essential. People are not going to use our products if they don't trust them. And they aren't going to trust them if we can't protect their privacy and security. The data shows that people actually do care quite a bit about their privacy. They care quite a bit about it in the context of this debate that we're having now. And I would just note that secret surveillance scales particularly poorly internationally, right? If you are a European government right now looking for a cloud computing provider or a storage provider, are you going to use Amazon Web Services? Are you going to adopt Google Docs? I think probably a lot of people are thinking they'd be crazy to do that right now. And they shouldn't feel that way. I think there are good reasons they shouldn't feel that way. But I think there's a real risk that we are going to see a real impact on businesses because of these revelations and because of the lack of transparency around them. And the risk there especially is that we're going to see a balkanization where people insist on keeping their data in places that they can see it inside their country. They are going to stop wanting the kind of free flow of information and traffic that has made in some ways a lot of our services and a lot of things on the internet successful. And I would just say also beyond the business impact, I think that has a very big impact on the NSA and on the FBI and all of our law enforcement establishments' ability to do this kind of surveillance, right? I think we live in a golden age of wiretapping right now, especially for the U.S. services. It's true. I mean, I think that we're very lucky that in the that many of the most successful brands online happen to be U.S. companies. They're very popular abroad, and because of that, we've given our government an ability to get access to information that other governments would really like. And over time, if we're not transparent about these tools, if we're not able to give people good answers about how they're being used, we really risk driving the data away, the very data that our law enforcement and national security establishment needs in some cases. So I think there are important business and national security reasons we should be asking hard questions. The last thing I will say is quickly about the public policy debate. We could talk about this more in the Q&A too. I think it's largely understood that the law enforcement establishment and national security establishment need access to information to protect us, right? The question is not whether they should be able to get any information. I think the question is what are the rules going to be? What oversight is in place? And I think Americans have a highly stylized view of how all of this works, right? We've seen it on TV. If you want to seize my laptop from my home, you have to go to a judge, you have to get a warrant. You know, the judge has to say that there's probable cause. You have to knock on my door, show me the order. I can go run to the judge down the street and say, hey, you've got the wrong Alan Davidson. There's another Alan Davidson down the road who everybody knows is a drug dealer. That's probably who you want. Those kinds of procedural and substantive safeguards don't exist for most of the kinds of orders that we're talking about. We're not talking about a probable cause standard. We're talking about a much lower standard, often based on mere relevance to an investigation. We don't have the procedural safeguards. Even when you're going to a judge, as General Alexander talked about, a tough judge, it's an ex parte proceeding. There's only one side of the story being told. And because we're missing those kinds of safeguards, we've got a real hole in the system, and it's not what I think most people are expecting rather, most Americans. So I just note that there are probably three big areas that we're going to see in the Washington public policy debate, real debate, in the coming months and years. The first is around these surveillance programs themselves. And the old conventional wisdom, I mean old by like a couple of weeks ago, was Washington's going to do nothing about the NSA surveillance and all the revelations of the last few months. I think there's been a little bit of a wake-up call. I think that the new conventional wisdom is, wow, maybe we will end up doing something. Polling data shows that a lot of Americans are concerned about this. There was a recent effort in the House of Representatives to defund a lot of the programs that we're talking about, and it narrowly failed by less than 10 votes. And I think that was a real wake-up call to people in Washington that this is an issue that is not going away. So there will be a lot of discussion about whether we can do more to have more transparency, to let people talk about what's actually happening when they get these orders. And so that's one area to pay attention to. A second is a bigger one, which is I talked about the sort of difference in standards in all of these areas. And I think we're going to have a real debate, and we're having a real debate about how to update our surveillance law to be more consistent with the issues raised by the third-party doctrine, to take care of some of the holes in the old laws that treat, for example, email that's 180 days old is treated totally different and less protected than email that's less than 180 days old. How does that make sense? There's going to be a significant update in our laws, and that's a debate that's ongoing and making real progress. There's a group called the Digital Due Process Coalition run by CDT and EFF and some of the other great groups who do work in this space, and I commend it to all of you who are interested in this debate. The last area that I think is extremely important but has gotten less play is the looming question of whether we will require a guarantee of tappability in all of our new services. Phone companies are currently under the 1994 Communications Assistance for Law Enforcement Act required to provide certain capabilities to law enforcement. There is a great effort underway and a great debate within the administration underway about whether the administration is going to pursue something similar for other services. And I think that would be very dangerous for all of the reasons that Matt's just spoken about. There's a lot that we can do that's independent of the law, thinking about how as companies and individuals we can try and be transparent in the way that that Brewster's talked about, in the way that some of the companies at Google, we put together a transparency report to show how many requests we got from all over the world. I think those efforts are really important and can be done independent to some extent of these changes in law, although some of them, for example, some of the companies still can't talk about, even in aggregate, the numbers of requests that they get for these are secret requests. I would just say I think there's a lot of technical work to be done in giving people tools to protect themselves, and also to create greater accountability in the surveillance systems that are fielded, so that we really do know when these audits that these audits are correct. And I would just encourage you. I'd say, this debate is going to be going on for many months and years. It really needs the input of the kinds of people who are at this conference. I hope people from this morning's conversation, from all the news out there, feel energized to engage in the debate. If we can't have our own house in order here in the United States, it's very hard for us to be out in the world arguing for internet freedom and human rights in ways that I think people feel are fundamentally important. I hope we can still show the world that we actually do have a rule of law and a constitutional system that has been the envy of the world, and it will need all of our attention. So thank you for your attention, and I look forward to your questions. Thanks.
I'm hoping that we have a few minutes. Please, questions?
Right, so I think there are a lot of different requests that come across the transom, and I think that cybersecurity concerns are an interesting new development because they could result in a lot of information sharing for purposes of cybersecurity, but then that possibly discloses a lot of information, creates a sort of regime where further information is disclosed, or information is then being held or protected by the government as opposed to private industry, and I think that's a big question that is coming up. As far as letters from Congress as a different type of attempt to get information, I think that I wasn't sure if what exactly your question was in that regard, but I think it is true as well that there are a number of different types of requests that come across. Honestly, national security letters that Brewster was talking about, those are sent by the FBI and are, as far as we know, not as broad as the programs that were being discussed by the NSA or the Snowden revelations. So there are quite a few different programs that people have to deal with.
May I? Mm-hmm. The area of voluntary requests for information when they come from the government don't feel voluntary at all. I don't think that the people in the government realize how much pain they produce by doing these, that there's it causes a lot of stir within organizations such as ours, a lot of conversations that are expensive to have back and forth with lawyers about how to respond. And this word voluntary, I think, just means that they don't have to pay attention to the law in many cases. One of the key things we found is don't have the information in the first place. Get rid of it. And suggest that more and more people could do without their IP addresses or the IP addresses that come in through their web logs. That if you have other tracking type things like cookies and things like that, often you don't need those things and they're toxic waste. They end up costing organizations a lot more by having them than they benefit you by having them. So if you need to be able to do security audits and the like, or if something's bad's going on, then we turn on IP address logging and we use it, and then after the threat is gone, we turn it back off again. And we find that this approach shortens conversations a great deal with people that you don't want to have conversations with. You know, folks like in the government, when they come and say, well, we want this information, and we say, well, we don't have it, they turn away and they go away, as opposed to trying to go and go through a process to get the information that they're looking through, either voluntarily or more forcefully than that. Any other questions? Yes.
Do you think that the people who are making the judgment calls, who are making the laws, are the right people to be making them? Aside from the fact that they're the ones that are legally allowed to make them, most of the people in Congress, it seems like they don't actually understand, and that's not anything against their intelligence. It's just a very big and complex field, and they didn't study it. So what can be done to help get laws made that are actually useful and protecting and safe?
Get involved. I think it is an excellent question, excellent point, and it's absolutely true. I think, the fact is that most members of Congress, very few members of Congress, have any kind of technical background or good technical intuitions. Beyond that, they're just extremely busy people. A lot of them are extremely well-meaning, but very, very busy people who are dealing with lots of different things. And as we know, these are really complex areas. And their staff are busy people, and they don't understand these issues that well. So I will just say, I think from a perspective of somebody who spent a lot of time in Washington, we need more people like you who know about these issues, who understand them, to get engaged, to talk to your members of Congress, to talk to their staff, to come to Washington, to work in these areas. These issues are not going away. They're only getting more complicated. And the starting point is a well-informed Congress, a well-informed judiciary, and then we can talk about, the debates about the substance. But honestly, a huge portion of what we all have done in Washington is just trying to make sure people understand what's going on out there.
Let me just echo that a little bit. I mean, my background is as a technologist, but I've spent a fair amount of time in Washington and talking to legislators and staffers and so on. And I remember the first time that I did this, I thought, okay, this is, these people don't understand what the issue is, and I can go and explain it to them, and as soon as I explain it to them, they'll understand, and then we'll have good policies. And there was a learning curve for me where I figured out that Washington is actually a little more complicated and a little more subtle than that. But what's interesting is to the extent to which that turned out to actually be true, right? We spent 8 painful years in the clipper chip crypto wars area in the 1990s, but at the end of it, kind of common sense and truth and justice won. And that's partly because, we spent a long time explaining it. And engagement is painful and slow, and it seems like it's not working, but it's really the best tool that we have.
Oh, yeah. I think also the idea of running the government is not often the right answer. So there's this, we heard it this morning, we heard it out of the president, there's a meme that's being propagated by the government that we really need a discussion around the trade-offs between security and privacy. You just hear it over and over again, that it's a discussion, it's a balance, it's a tipping a scale, there's needles. I don't think this is true at all. The framing of this problem is not at all that, at least in the information sphere, it seems more like security versus broken technology. Broken technology that's either buggy or deliberately broken, and broken in the sense that it's not serving what the users want. So if there's an area that that's a tipping of a balance, it's between security, and if you have secure technology, you get privacy for free, or broken technology. And in a group like us and the technologists that gather in this conference can have a great deal of influence into making non-broken technology. The idea of having inadvertently buggy technology that's exploited professionally, and then there are people incentivized to go and have buggy technology, either on purpose or not on purpose, I find really quite frightening. So what can we do? We can make better technologies that don't have these problems in the first place. And if you don't have the technologies to go and have these opportunities for people to try to exploit, often the problem just goes away. So I'm not saying that there's no role here for government laws, but let's make their job a little bit simpler. Let's build some better technology.
Yeah, I can't help but think we're cutting into the next panel.
Is there another panel that's supposed to be here?
You're going to break at this point.
Okay. So it's either us or cookies or whatever. So take your pick.
In that case, we can take one more.
Yeah. Okay, you're keeping people from cookies, so go for it.
So addressing the statement you just made, we can design technologies that don't have these backdoors, that don't leak the information that we don't want. But then we find that the law enforcement lobby just makes an end run and mandates that we build these into our telephone switches or into our ISPs. So what do we do about that?
Yeah, again, I'm going to echo what Alan started with. You know, the only real weapon we have is engagement, right? I mean, we have to explain why these design mandates are, you know, civil liberties aside, technically incredibly dangerous. And they're technically incredibly dangerous, you know, for really important fundamental reasons. And, you know, we have a real advantage in this debate. We're outnumbered by, you know, the law enforcement lobby that is very powerful. But on the other hand, we're actually right. You know, and you know, right isn't, you know, the end of the discussion, but at least it is still worth something. And, you know, and we really do have that here.
And I would just note that it is true that that debate was lost in 1994 in some ways around telecommunications capabilities, but there's still a big debate to come about other kinds of communications technologies on the internet. And I'd say stay tuned for that. It's really lurking under the surface right now, but it's going to be a big fight, and that's really where we're going to need people's attention.
Right, and I would emphasize that the argument that I've seen work best in that regard is the argument that Matt was making about these backdoors actually creating other vulnerabilities. And I think that that's where the technical community actually has a lot of power in this, because legislators don't really understand the technology as well. So if you have somebody get up and testify to Congress, as has occurred, that you know, if you mandate this, we're going to have the Chinese government or whoever able to more easily break into our infrastructure, that actually goes, I think it has gone farther than civil liberties arguments have. So.
Push back, push back, push back. I mean, if people are telling you to make crappy technology, they don't really understand what it is they're asking for. And so they're push back, and often you'll find that they're quite thankful for your having done so. And there are others that can help in this explaining it, and are professional at explaining these sorts of things. You have more allies than you know. Often it feels quite lonely if you're given sort of these mandates from on high that are completely vague, weird, technical, you know, they have technical implications, but, you know, how do you interpret it? Push back, bring it back up, and your organization may actually be better off, as we're starting to see some of the large information providers on the internet sphere. It's the ones that are pushing back that are looking better to both to customers, to the general populace, and I would imagine to most people, even inside the government.
Okay. So thanks, everyone.
Thank you.
Thank you. Is some of what it is we wanted to know was how would our partners react to this. The Internet Archive works closely with the Library of Congress, with the National Archives, with governments around the world to work with them on collecting web pages and being a library and digitizing books and the like. And when you sue the United States government, there's this question of sort of what would happen, you know, and given that the United States government isn't all of one mind, when the announcement came out in the Washington Post, there was a conference call back and forth, normal conference call back and forth with the Internet Archive and the Library of Congress, and the people that we were working with said, I heard this clatter on the other side, and they said, Brewster, you can't actually see what it is we're doing here, but we're all standing and giving a round of applause to the Internet Archive. So the idea of pushing back on these can not only, you can do it, but it often is, you have more friends than you can imagine. So this is the creepy thing about all of this had to be done in secret. That there was no one I could talk to, I couldn't clear it with my board, there was nothing I could really feel that I could do. So this area that we've started to find is as a the government in this circumstance, by keeping things secret, are caused. So that's a little drastic. Is there somebody I can consult? I said, no. Can I ask my board? No. Can I bring this up with my family? No. You have to make a decision on your own to sue the United States government about this. And even if you sue the United States government, it will probably take so long that you'll miss the deadlines, so that you'll risk criminal charges just by doing this. So, oh, this is thrilling. Yeah, you're right. This isn't the best day of my life. Well, so I had to think about it, and on my own, we decided to sue the United States government. The ACLU and the Electronic Frontier Foundation offered pro bono help, which turned out to be absolutely critical, because if I'd started to spend money on lawyers' fees, then other parts of the organization would start to know that something was up. So it's very, very peculiar, very Kafkaesque. Just you can't respond in these environments unless you have a friend such as the Electronic Frontier Foundation. So we filed a suit that was under seal. It wasn't with the secret courts, but it was under seal, so that there was complete secrecy about it. And it started a very nerve-wracking several months. What happened after we sued, it turned out that the FBI didn't need the information after all. And they basically wanted out. They just said to the Electronic Frontier Foundation and then met with them. And then I got a call, and they said, well, we can't really tell you over the telephone what it is we're going to talk about, but we need a meeting. And so we met in a conference room at the Internet Archive. They specifically asked to not the people that were, the FBI agents, you can't talk about this on telephones, which I guess we're now starting to understand why. So we met in a conference room, and he said, this is not a good day for you, Brewster. We've just received a national security letter. It's one of these national security letters that has a gag order to it, so that not only do you have to just answer the questions, and you can only ask people what it is they've been allowed to, that you need to be able to answer these questions. You can never talk with anybody ever again that these questions ever came in. This is not how you ask a question of a librarian. We're in the business of answering questions for people, and this is not one of them. It was very uncomfortable. I didn't know what it is I could do, so I asked, what can I do? And they said, well, you can basically, according to the law, answer it quickly, and then never talk about it again. And I said, or what? And I said, well, you could risk criminal charges and go away for 5 years. Said, is there any other options? And they said, well, not really, but so the only way that you can push back on one of these things is to sue the United States government. This is the panel on, what is the official name of our panel?
Law enforcement access, we're going to go.
Law enforcement access to information.
Or lawful access.
And we have different perspectives on this panel. I'm going to take the perspective of the person that's been requested information of, or as I like to think of it, as how not to ask a question of a librarian. I am the founder and digital librarian of the Internet Archive, which is a nonprofit library in San Francisco, and we had the delight of getting one of those nasty national security letters that have a gag behind it.
What is your name?
Oh, my name is Brewster Kale. And so we're going to keep this short enough so we can actually have some level of discussion and back and forth. So we run I run an organization that has a lot of material from end users up on the internet. We're probably best known for the Wayback Machine, but we also host books, music, and video at massive scale. We have petabytes of information to make it available, but as a library. And so there was a day when we were visited by a couple of FBI agents. They came knocking at the door, and they met with our office manager. We don't have legal staff. So the office manager said, you kind of came to the wrong place. If you want to talk to our lawyers, you have to go and meet with our lawyers, which are the Electronic Frontier Foundation. So they went, we're done. It's okay. You know, just go away. We're over. Doesn't matter. And we said, not so fast. That if we've gotten this far, we want to make a cookbook for those that are in my situation, such that we want to go public with as much information about the demands and all of the counter back and forth that are going to go on as part of this, and we want to be able to post it on the internet for free public access. And so we did this negotiation with the FBI, and of sort of when would be redacted and by when, so that they couldn't drag it out forever and ever. And this is a negotiation that took several months, and then it was cleared up. All in all, about 6 months later, and we had a press call to be able to announce that this is one of the only of the three, at least at the time, public pushbacks against these national security letters. There have been hundreds of thousands of these, we know, because Congress demanded to know how many there were, and that was a lowball estimate, because a lot of these national security letters are never even written down. They're just call up, hey, I've got a national security letter, you got to give me the answers, as according to this congressional report. So there was only three that have pushed back, and so we did, and we finally went public with it. What was, I think, very helpful out of this